Okay, assalamu alaikum. Thank you, everybody who came out today on this cold January day. And thank you to IAGD for inviting me to speak today. Many of you already know me as Hussein's wife, Hussein Akbar's wife. I've been in this community for about 16 years now. But I think many people probably didn't know that I'm also a licensed attorney. So I practiced for a couple of years when I first moved here, and then I took a long time off to be a stay-at-home mom. And then the last few years, I've started working again with Hussein's law firm, Just Right Law, or Ahmad and Akbar Law. So I do mainly estate planning and probate work. I also do Islamic estate planning. My bio was supposed to be on the website, but this is what happens when you work with your husband. So today's presentation is about estate planning. What is it? Who needs it? Why do we need it? And then I'll touch briefly on Islamic estate planning as well. I won't be going into too much detail about the inheritance rules. I think the plan is to have Dr. Shah hopefully do a more in-depth lecture on the inheritance rules. And also, I have to give design credits to my sister Aisha, who thought that my original PowerPoint was too boring, and so took it upon herself to make it look much, much nicer. So what exactly do we mean by estate planning? The word estate sounds like a fancy word that applies only to rich people. But that's not true. The word estate just means your assets or everything that you own. So your house, your car, your bank account, retirement account, jewelry, and so on. And then the planning part of it applies mainly to two situations. Planning for when you pass away, and planning for a potential future disability or incapacity. And that typically involves setting up a series of different legal documents in order to prepare for these two situations. And we'll talk about what those documents are in just a minute. But first, I wanted to make a quick point here. Estate planning is not just about planning for your assets or planning for your inheritance. Estate planning can include planning for a lot of other things. And I'm not going to go through this whole list here. But the point I want to make is that a good estate plan should be comprehensive, and it should be tailored to your particular circumstances. And a good estate planning attorney should evaluate, what are the client's needs, what are their goals, how are their assets titled, what is the family situation, and what other factors need to be addressed. It's very easy for people to go online and get the documents, but are the documents doing what you really want them to do, and are they overlooking something that really needs to be addressed? So let's go ahead and talk about some of the different legal documents. First is the will. The will is the document that describes how your assets will be distributed when you pass away. So if you own assets, then at the very least, you should have a will. And there's a couple other things that happen in the will, But the one thing that I really want everyone to remember is that the will is where you will name guardians and conservators for your minor children. And this is if both parents were to pass away. The guardian is responsible for the physical care and the custody of the child, and the conservator is responsible for any assets that belong to the child. So if you don't have a will that names guardians, then eventually the court will end up deciding who the guardian will be. And then you can have family members arguing over who should keep the kids. And the kids could also be placed in the foster system until the guardianship issue is resolved. So if you have minor kids, it's really important to be proactive and set this up now. We've seen situations in our own community where husband and wife have passed away at the same time and leaving behind their minor children. So it's not something to take lightly. So there are some other key points about a will that I want everyone to remember. First, a will must go through the probate process after you pass away. So probate is the legal process that happens in probate court. And the will has to be submitted there, and then the probate court has oversight over the distribution of your assets to your will beneficiaries. Probate takes time, up to a year or longer. It can be expensive. We're talking a couple $1,000s. It all depends on what the estate is and if there are any challenges or other issues going on. And then the second key point that I want people to remember is that the will only controls assets that are in your sole individual name. The will does not control joint assets that have rights of survivorship. Those assets will automatically go to the joint owner when you pass away, outside of probate and regardless of what the will says. So if you own your house jointly with your spouse, if you pass away, that house will automatically go to your spouse, outside of probate, and it doesn't matter what the will says. And then the will does not control assets with a named beneficiary. So like an IRA or a 401k, or if you have a life insurance policy, if you have a named beneficiary listed, those assets will go automatically to that named beneficiary outside of probate and regardless of what the will says. And lastly, a will does not control assets that are placed in a trust. Those will be distributed directly to the trust beneficiaries by the trustee. And you will see that sometimes people place assets in a trust specifically for the purpose of avoiding probate. So this is an important point to remember about wills. A lot of people assume that your will is going to control every single asset that you own, and that's not true. When we're doing estate planning, it's crucial that we look at how the assets are titled and what is it that we're actually trying to accomplish. So what happens if you don't have a will? The assets that are joint or that have the beneficiary designation, those will still go to the joint owner or the beneficiary, but the assets that are in your individual name, they still have to pass through probate, but they will be distributed according to the rules set up by the state, which may not have been what you wanted, and it may also lead to conflicts among family members. Arguments about who should be the personal representative or who should be the guardian or dad wanted to do things Islamically, so now you owe me my rightful share. We've all heard the horror stories. So put things in writing and hopefully avoid all of these problems. So moving on to trusts. A trust is essentially an agreement where a trustee manages and distributes your assets for your trust beneficiaries based on the terms of the trust. So you can think of a trust as an alternative way to distribute your assets. Rather than relying on a will, you can transfer assets into the trust, and then your trustee can distribute those directly to your beneficiaries. But even if you have a trust, you will still have a will. Typically, it will be a special kind of will called a pour-over will. So either you will have the will by itself, or you will have a trust or multiple trusts with the will. And there are different types of trusts for different purposes. The most common type of trust is the revocable living trust or revocable living trust. The other main type of trust is the irrevocable or irrevocable trust, and those are used for more limited purposes. So one of the most common questions that I get is, how do we decide between a will and a trust? Do I really need to have a trust? And the answer is, it depends. Not everyone will need a trust, and not everyone will want to put in the effort to make a trust. It all depends on the situation. And I outlined some pros and cons here. So hopefully this can give you some guidance in thinking about a trust versus a will. First, a trust that is set up properly can avoid probate and thus avoid the cost, the hassle, and the time that's involved with probate. If you have a smaller estate with simple assets, then it might not matter as much, but if you have, the larger your estate gets, the more complex assets, if there are other issues going on, then avoiding probate might be a good idea. And then going hand in hand with that is that a trust allows for private management. Probate is a public process. So probate is a public process that happens through the court. A trust, on the other hand, allows you to name your own trustee who can distribute your assets privately without any court or state involvement. So a lot of people really value the privacy of a trust. Next, a trust gives you more control over how assets are distributed compared to a will. The example is if you have children and you have just a will, those kids will get the full control of their inheritance at age 18. But with a trust, you can extend that to a later age until they're a bit more mature to handle all of that money. And in the meantime, your trustee can manage and distribute assets to them, but they won't get full control until they're a bit older and more mature. And then another advantage is that the trust gives you more options for dealing with different kinds of assets, such as joint assets or assets with beneficiary designations. So there's just a lot more flexibility with a trust than a will. And lastly, the trust can also help reduce estate taxes, but this is only relevant to very, very high wealth people. And then some of the cons. Trust, of course, is going to be more costly than a will. We're talking a couple $1,000s depending on the type of trust. But having the trust could potentially save your estate money down the line after you pass away. And then the trust requires more upfront work than a will. Maybe you have to transfer assets or retitle assets or change beneficiary designations. Some people don't want to be bothered by that. And then for certain trusts, mainly irrevocable trusts, they may require annual tax returns. So that's just some food for thought. Everyone's situation will be a little bit different, and an estate planning attorney can help you make those determinations about what type of plan would be appropriate for you. So moving on, we'll talk about a little bit about powers of attorney. So powers of attorney are documents that you set up now to protect yourself just in case something were to happen to you down the road. If you were to suffer a disability or incapacity and all of a sudden you become unable to do things for yourself. There are two main types, the healthcare power of attorney and the financial power of attorney. And these are lifetime only documents. They have nothing to do with after you pass away. After you pass away, the will and the trust take over. So the healthcare power of attorney. So if something happens to you in the future, you're in a coma, you have a bad stroke, you get Alzheimer's, the person that you named in the healthcare power of attorney, they will have the authority to talk to your doctors, make treatment decisions for you, decide where to admit you, all of those things. And then in the power of attorney, you can also specify what your wishes are about your medical treatment, and specifically your wishes on termination of life support. Sometimes people put this in a separate document called a living will, but you can also include it in the healthcare power of attorney. And then we have the financial power of attorney. So the person you name in the financial power of attorney will have authority to deal with your assets. They'll be able to talk to your bank or your insurance company, pay your bills, sell your property. Most powers of attorney are comprehensive, and they can cover a lot of different things. Or you can have a limited power of attorney specifically for a single purpose, like selling property. So what if you don't have a power of attorney? If you don't have a power of attorney and suddenly something happens to you and you cannot act for yourself, then your bank or your insurance company or the hospital, whoever it is, they may not speak to your family members without a court order. So your family may end up having to go to probate court to get a guardian and a conservator appointed for you in order to be able to handle these tasks for you. So it's so much easier just to have the power of attorney already set up so that if the time comes and it's needed, your family has it. So I'm going to shift gears here and talk a little bit about Islamic estate planning. One of the most common questions that we get is, does American law or Michigan law allow me to distribute my estate according to Islamic Sharia law? And the answer is yes, but there are some caveats. Okay, so in this country, you are free to distribute your assets as you wish, but you must put that plan into writing, okay, either a will or a trust, and you must explain how the distribution is supposed to be. What are the shares and who's getting what? And second, we learned that the will only controls assets that are in your individual name. So if you have joint assets or assets with beneficiary designations and you want to distribute those Islamically, then it may require some additional planning on your part. It's not just about having the will in place. You also need to be thinking about how your assets are titled. And then lastly, if you want to distribute your estate strictly in accordance with Islamic inheritance law, then there may be trade-offs. You might not get the most ideal tax result. You might have to do more complicated planning, like a trust, which means more work on your part. So there's not always going to be a clear-cut and easy answer for how you set things up, just because of the way that the property system is set up here in America. So I just have a few quick points about the inheritance rules. We'll leave the details for Dr. Shah, hopefully. So when most people think of Islamic inheritance, they think of the rule that the sons will inherit twice the share of the daughter. And yes, that is one part of Islamic inheritance, but there's a lot more to it than people realize. Who inherits and how much they inherit can change based on which family members survive you. So when we're talking about the mandatory part of inheritance, there's also a discretionary part to inheritance. The mandatory shares are based on prescribed shares laid out in the Quran. And there's a core group that will always inherit if they survive you. So that's your father, your mother, your spouse, and your children. And this is the same for Sunni and Shia and all the schools of thought. It's when you get to the shares of other relatives, that's where you'll find some differences between Sunni, Shia, and the different schools of thought. And I'm not going to get into the actual fraction of shares today because that will take a lot of time. But just, so you have this core group, and then outside the core group, there are some relatives who may inherit depending on the absence of certain core relatives. And this can vary depending on the school of thought or the sect. And lastly, there's a certain class of people who don't inherit under the mandatory shares. And this includes non-Muslim relatives, adopted children, and other non-blood relatives. So if your father or your mother or your spouse is not a Muslim, then they don't get the fractional share that's set aside for those family members. However, for those people who were left out, you can still provide for them through what's called the Wasiyyah, which is the discretionary portion of inheritance. So you are allowed to distribute up to 1/3 of your estate to those people who are not getting a mandatory share from you, or you can give it to charity. So if you want to leave a share for your non-Muslim spouse or adopted child, you can still do that through the Wasiyyah. Just to note here that under Shia rules, the 1/3 Wasiyyah can go towards those people who are already inheriting a mandatory share from you, but I believe under Sunni rules that's not allowed. And this is entirely discretionary. You don't have to utilize it if you don't want to, but the rest of the estate still has to be distributed according to the mandatory shares. And the Wasiyyah gets distributed first before the mandatory shares are doled out. And lastly, I just wanted to make a few brief points about how we incorporate all these rules into the estate plan. Since we don't know who will survive us and who will pass away before us, there are many different potential outcomes for the shares. So typically people will attach a schedule of all the potential possibilities. Many of you may have seen the Mawarith schedule used in the ISNA wills. It's very long and it can be difficult to follow. So what I've been doing now in my wills and trusts, I try to tailor it to the particular situation as much as possible, depending on which of the current relatives are living. either by outlining the shares in the will or the trust, or having a more simplified schedule. Then you can include Wasiyyah gifts in the will as well. And then another issue is how to address the joint assets and assets with beneficiary designations. If you want to distribute those Islamically, then you may need to take some additional steps. And this could mean using trusts, like a joint trust for joint assets, or naming a trust as a beneficiary of certain assets. If you don't want to do trusts, then there are some other options. You could do like a custom beneficiary designation. There are also postnuptial property agreements you can do. And sometimes people have informal agreements between family members. And some people decide, hey, I'm just going to let my estate pass to my spouse, and then ultimately it will go to my kids according to their Islamic shares via my spouse's will. And that's a possibility depending on the situation, but there are some issues with that from a legal perspective and then also Islamic perspective. So you need to talk things over with your sheikh or scholar first, and then talk to an attorney as well about what the potential ramifications are. Another issue is state elective shares. I won't get into all of this, but each state has a mandatory minimum that has to go to their surviving spouse, and it can be a lot higher than what the Islamic share is. So there are ways to bypass that. Trust is a good way to avoid the elective share issue. You can also have property agreements. And then another thing that people don't consider as often, and I've spoken to some scholars about this, is that family members can agree to give up their shares, or they can even agree to an alternate distribution. Perhaps the parents don't want a share of the inheritance and they want it to go to your kids. This could be a potential way to simplify the process. But of course, could be difference of opinion about this, so you need to consult with a scholar first. And you noticed a recurring theme, and that is to use trusts. Because of the private nature of the trust, the flexibility of the trust, the options of the trust, it's often going to be a good choice for people who want to do a very strict Islamic distribution. But obviously the downside is it's more cost and more work. And as an estate planner, I'm always trying to find new and better ways of doing things because Islamic estate planning requires creative planning. You have to think outside the box. And it's a constant learning process for me. So I hope that as I grow more experienced in this role, that I can become even better at addressing some of these different issues. So that brings me to the end of my presentation. The big takeaways here are that, one, it's important to plan ahead. Put some effort into this now and save your family the headache down the road, or even the heartache if something goes wrong. As Muslims, we have an obligation, if we own assets, to have a written plan in place. So we need to fulfill that obligation. And then when you're setting up an estate plan, it's also important to think about the bigger picture. What are my goals and how are my assets titled? What other issues might need to be addressed in addition to my assets? And this is where the guidance of an attorney can be highly beneficial. And before we end, I would be remiss as a lawyer if I didn't leave you with some disclaimers to read. So here are my disclaimers. Today's presentation is for educational purposes only and should not be taken as legal advice. And then for fiqh-related questions, please consult with a qualified religious scholar. And that's it. That's the end of my presentation. So thank you for listening.